Hello, and welcome to Campus Docket, a Volt podcast about the legal challenges reshaping higher education. I'm Scott Schneider, attorney and adjunct professor at the University of Texas School of Law, and I'm joined by Eric Kelderman, senior writer at the Chronicle of Higher Education. Each episode will unpack the key legal developments that matter to higher ed leaders, student rights, faculty contracts, to DEI lawsuits, and government oversight. Campus Docket is produced by Volt, the go-to news source for higher ed leaders and decision makers. Remember to visit Volt at voltedu.com and subscribe to Campus Docket on Apple Podcasts, Spotify, or wherever you get your podcasts to make sure you never miss an episode. Let's get into this week's show.
Hey, welcome everybody back to Campus Docket. We have Scott Schneider, and today we're joined again, a repeat offender, a repeat victim, Neal Hutchens, at the University of Kentucky. Neal, tell us
three strikes, he's out.
Yeah, right. Yeah, he's going to be getting a call from his HR department right after this releases. Neal, tell us what's your title there exactly? I'm always confused about what's your title.
So I'm a faculty member in the Department of Department of Educational Policy Studies and Evaluation, teaching in the higher ed area. And so I'm a professor, but also have a designation as a university research professor, which we're allowed to put in our emails and such. I'm not sure what that really means, but I'll take it.
I just wanted you to say that so I didn't have to use all my breath. So normally we might do, Scott and I might do a sort of like quick takes on recent legal developments, but today's show is really going to be just all about a wide range of very interesting and important legal developments that are happening in the world of higher ed. But before we do that, we have to do our icebreaker. And this week's icebreaker, we may have actually done this before, but the most overrated rock band. And Neal, you get the honor of starting.
Well, I know this is a band that a lot of people like. I've seen them in concert. I think that they've got some really good stuff. But I'm going to have to go to U2. I never quite understand some of the deep fascination with U2. I like a lot of their music, but I've never gotten to the level of adoration that I see some people have had through the years.
Yeah, it's like a band with no rhythm section, no guitar player. It's just horrible. Like any band that forces itself onto my iPhone one night is verboten for me as well. Here's mine, and Eric before the show said he would predict mine, but this one is super easy for me. I despise the band Kiss. I think Kiss is horrible. Like, I do not for a second understand the allure of Kiss. And they literally may have written and performed the worst song I've ever heard in my life, which is that song, God Gave Rock and Roll to You. It is just so bad. That entire band is horrible. Not one redeeming quality. I think the Ace Frehley guy's good at guitar. Maybe that's it. But that's my answer to that question.
I think the way you have to look at Kiss is it's a very good backyard party band that somehow got a recording contract. That's it.
What was your guess, by the way? I can't see that.
Oh.
The Eagles are terrible too, man. There's no question about that. But Kiss is on another level.
Okay. I'm going to say something I think is going to be really controversial for both of you, and maybe Scott in particular. And the one band that I never understood the fascination with this group. It's full of great musicians, but I never liked the Doors at all.
Okay. I support that. Can I tell you just a quick story?
Yeah.
And I can't get into the details because I'll get in big trouble. But a long time ago, John Densmore, who, if I recall correctly, was the drummer, was doing a campus speaking tour and came to New Orleans. And I have had drinks with John Densmore. He was actually a pretty cool guy. But no, the Doors, I'm with you. Like, as a front man, and what's the guy's name? Oh my God, I'm blanking. Jim Morrison. Yeah, pretty compelling, but the songs are just they're horrible.
It just never jived for me. And the keyboardist and some of the other musicians in the band were world class, really great, but I just never got into it the way I guess a lot of people did. So whatever. So that's our that's our show for today, folks. See you later. No, we're gonna we're gonna talk about a range. There's been a lot happening in the higher ed legal world, and we're gonna start with something. A little more than a week ago, the Education Department released this letter from Secretary McMahon to higher education broadly. It's not really a dear colleague letter. It's a list of issues that it wants colleges and universities to address, not by creating new policies, but by putting up, I guess, answers to questions about how the institution is going to make itself more affordable and less ideological. It's sort of a light version of the compact that the administration tried last year when they asked 9 universities to sign on to this thing in order to receive some preferential treatment for grant money. And what's fascinating about this one is, as my colleague Francie Deep has reported, it was created in collaboration with some of the leadership of the AAU and some prominent university presidents, including those at Arizona State, Washington University, the University of Kansas. They have all issued varying levels of either confirmation or denial about their involvement in that process. And in this case, it's supposed to not be tied to any money, right? It's just, I guess, a gesture of goodwill that the Ed Department, which boggles my mind. Like, if it's voluntary, if the Ed Department isn't going to use it to enforce any of its regulations or funding priorities, why do it? Anyway, Neal, what are your thoughts about this?
Well, one is what you just mentioned, is that there's this question of there's the so what question. What are institutions, the public, everyone else supposed to make of, I guess, what is the wording language in prominent signage somewhere online, your institutional web pages to show you support these, the sentiments that are expressed. And so that's a real question. When you read the letter, there are also a lot of parts of the letter that, yes, transparency, good, that I don't actually think are that people would really have much to dispute over that. And the idea of affordability, for instance, there are a lot of parts of the letter that seem, they're pretty ho-hum. They're at a very generic, broad level. There's not a lot that you can see actionable for an institution to take. I think probably two of the more controversial ones, there's certainly the statement about certain academic units that have engaged in activism, and institutions need to really target that issue in relation to pluralism. Probably the one that I think is most significant, and it doesn't mention it in the letter, I don't think, but it's tied to the recent rules that are going into effect for international students about this notion of really prioritizing American students, domestic students in programs. And certainly under the rules, I don't know, Scott, if you've encountered this with clients or something going on, but the idea that when you're showing up, you've got 4 years, limitations on transferring if you're even in a doc program. So certainly, for instance, like if you want to pursue graduate study, doctoral study under these new rules, you're probably going to have to get exceptions to do that if you're an international student under the rule, because I mean, you've got your 4 years limitations on changing majors. So that was the one that really stood out to me, I guess, as a conversation starter about this idea of the role and place of international students in a program at an institution or various programs. And so I'll just pick one out there is we think about, for instance, in certain medical fields, all of us, I think anecdotally, we know that when we or family members or others see specialists, the United States relies heavily on training students who are domestic students, but we also have a very rich tradition of in health fields and other fields where we have individuals who are incredibly talented that come start, from another nation and do their study here. So that's the one that stood out to me that is an important conversation point, especially if we do think about the recent rules that have gone into effect.
Can I go to a weird place? Did you all, and I might be a little, I've decided to get back on Twitter and make it almost like a blogging tool for me. I'm getting back to blogging, but did you all follow the $20 burrito conversation at all?
I read about it. I'm not on Twitter, but I did read about the back and forth on the burrito conversation.
Yeah, I'm going to go to a weird place with all of this. I mean, there's clearly this, what we have thought of as conservative politics in this country. And, Trump at some level epitomizes this. I mean, is we're in the midst of a rethinking, and that whole $20 burrito conversation was this, the free market conservatives and, versus the kind of common good conservatives where, JD Vance is kind of in, that school. And it's a long way of saying, I went down kind of a rabbit hole to try to understand sort of the common good conservative approach. I mean, it's clearly championed by someone like J.D. Vance, at least intellectually. And then you see it sort of operationalized by the Trump administration through this approach with higher education. And I stumble upon this. He's a professor at Notre Dame. I think his name is Patrick Deneen. Have you all heard of him? Super obscure. I say super obscure. I mean, he apparently was Hegseth's teacher at, I think, Princeton, and is sort of an intellectual advisor for J.D. Vance. But he has this approach, and you kind of see it with like Chris Rufo and that crowd, which is like historically the conservative approach to education and the relationship to higher colleges and universities has been, and this can be oversimplified, one of basically saying the government shouldn't be all that involved. I mean, that, I always bring this up, but the Dear Colleague letters, that are really consequential come from Democratic administrations, and then Republican administrations prior to that, were not willing to go that far. In this kind of new strand of conservatism, and you really see this like with Rufo on steroids, but Deneen is sort of the intellectual heavyweight who's put this architecture together. Is, in essence, these colleges and institutions are super important in the development of citizens. And we're going to switch from a policy of neutrality towards colleges and universities to one in which we use colleges and universities to advance certain very specific ideas. And by the way, you start to see this play itself out, I think, in some measure on the Compact 2.0, but also kind of a rethinking of core curriculum. And here, like, for instance, in Austin, I know Jim Davis just came out with some recommendations for the first time in 20 years about changing the core curriculum. And which I think is a good process, but, more of there's a Western Civ focus and certainly less of a focus on the gender studies and the things that were really big targets in like Chris Rufo and all those sort of folks. So it's just kind of interesting that I think historically the politics for higher education had been, when you get a conservative administration in, the regulatory climate dials back a little bit. And that clearly isn't the case
Right.
now.
Yeah.
And do you have like pinballing changes in compliance obligations depending on and significant changes depending on which administration is in power? And it was just really interesting to kind of it's just a very different Republican Party and conservative movement than you probably had, well, certainly that you had 20, 30 years ago.
That's a great framing for this. But now, what do colleges do? Nobody signed on to the Compact 1.0. Some folks offered to do it. Some smaller, less prestigious schools and were offered the Compact in the first place. Nobody signed on to it. But should you, as a gesture of goodwill, should you, as a means to perhaps lessening the risk, the legal risk that the administration is going to come after you for something in the future, should you comply here? What if you're a campus GC or you're consulting with someone? What do you tell them?
Well, it's interesting, and I'd love to get Neal's take on this, but, I had this thought the other day about typically if you're rolling out a new policy or a consequential approach on campus, historically, the model was it just took forever because you had to visit with and build consensus with a whole host of different stakeholders, depending on how significant the policy was. You have to go through, faculty senate, and I've sat in on my fair share of those meetings as well. But like institutionally, colleges and universities were not as reflexive or as quick to adapt because of the structure that existed to sort of slow things down a little bit. And so it's a long way of saying one of the things I find interesting, and certainly in a place like Texas, and I think it's consistent with sort of the broad theme I was painting, is we're taking a lot of those constituencies out of the mix. Faculty Senate being the most obvious example of that. And we're going to give politicians or boards who are closely connected with politicians and are ideological much more authority over the way in which institutions of higher education, obviously especially public institutions, especially right now in red states, operate. People, especially in whatever we're calling the red states now, they, number one, have more of an interest in what is being done in institutions of higher education, and some of that is influenced by some of these intellectuals, and now are putting in the means to get more, well, from their perspective, it would be less woke, less DEI, but also policies at institutions that more align with the politics of the state.
And we've seen state laws in Texas and in Kentucky in particular, where those shared governance structures on campus have been diminished, right? Specifically just advisory roles, and that's been a big concern for faculty. That's right, Neal, yes?
I think that's accurate. The short, or one of the thumbnails I use for this, and I think it's a potentially interesting development for higher education nationally. For a number of years, for both public and private institutions across the country, I think they were moving towards a state. They had a lot more similarities than differences. I think that what we're seeing is a bifurcation potentially. And so in more conservative states, one of the thumbnail phrases I'll use to describe this is a K-12ization of higher education. And by that, I mean in the way that state legislatures had previously been willing to be involved in curricular issues for K-12 schools. I mean, you'd have curriculum boards, et cetera, in a way that they hadn't really often been involved in higher education. That's changing. And so we have, with changes to the general curriculum, you have in places, I guess, what is it for Utah and Utah State, kind of this college that has been set up to offer the general education classes. As Scott was saying, this emphasis on Western Civ. And if you look at some of the legislative language in these states, it'll talk about, we want Plato, we want this, the ideas that have contributed to the development of Western civilization. And so that's a role that traditionally had been, a lot more deference, at least to faculty expertise. And maybe I guess we can call it now, since we've got the title, in response to Woke 1.0, has been a pretty harsh pushback in some states. And I don't know if once that curriculum genie is out of the box, if states that are moving towards more and more regulation and interest in curricular matters, again, in Texas, Scott, you've got your ombud who can now supposedly investigate claims that people may bring. Indiana institutions have adopted similar language. So that involvement is certainly different. I think that also, and this is a way that's perhaps different if we think about local control, and that's all often emphasized with K-12, is really it's just a trend that's been present in higher education. It's often done because you need to be efficient. You need to not stifle innovation. It's just really a top-down governance structure that is developing more and more at a lot of institutions.
And let me just plug one other thing before we move on, which is that in terms of, and I think this speaks to Scott's discussion about sort of the evolution in higher education, but a book out by Barrett Taylor at the University of North Texas and Brendan Cantwell at Michigan State called The Post-Liberal University. Mm-hmm. And they're, just very, very briefly, their contention is that, we've had debates about whether higher ed was a public good or a private good, and that has implications for funding. And Barrett and Brendan's assertion in the book is that higher ed is now a partisan good. So who gets higher education and how it's delivered is now going to depend on who controls the state government. For folks listening in, that might be an interesting read for y'all. And I can't believe I just used the phrase.
I think both of them are excellent scholars, and I think that's, whether you agree with their conclusions or not, I think it's provocative and certainly a really worthwhile book about this notion of partisanship. And I think that raises real questions for public higher education. And that's whether you come at this from the left or the right. Do we really want our public institutions to be constantly, and this would be more true for maybe purple states, and we've seen some of this play out in Virginia, like this constant push and pull back and forth? Is that, so in some ways is this whole notion, and Scott, I think this relates to some of what you were saying about this conservative push about imposing certain or putting in place certain thoughts or ideologies in higher education, which maybe is in opposition to other efforts. Like, what do we mean by a public university? Is it just, again, are we going to administer it like it's the 13th and 14th grade and above that we do with other schools in the state, or is it something different? And I think those are questions that are out there in a way that they haven't probably been in previous years and even the last decades.
Yeah, but you can also, by the way, see the beginning of kind of a more pragmatic pushback. And, the place in the search, I think, and I'm talking about him a lot, but, there was clearly this concerted effort to sabotage the presidential candidacy. What was his name? Santa Ono?
Well, first Santa Ono and then Stuart Bell.
Yeah. And so it was very successful with Ono, what was it, a couple of years ago now? With Bell, the idea that Dr. Stuart Bell and was it like an avatar for wokeness is itself utterly absurd, right? I mean, let's just be honest. I mean, I'm pretty reasonable, and so part of it was the allegation really wasn't supported by much in the way of evidence, but there where what you saw was both at the board level and even DeSantis and the AG stepping in and going, whoa, stop. This sort of litmus test makes us look dysfunctional, right? And is negatively impacting the University of Florida's current and its trajectory. And really much to the chagrin, I think, of, certain folks who did have a lot more sway a couple of years ago, basically stiff-armed them. So you can kind of start to see maybe a little bit of the pushback on that in the Stuart Bell presidency election. And I will come out and say, I know Stuart Bell. I like Stuart Bell a lot. I think he's fantastic. I think he'll be a great president at the University of Florida. And kudos to Governor DeSantis and the board for putting him in that position.
Well, Scott, I'll say as an alum of Alabama Law School, the characterization of Stuart Bell as a woke warrior had me laughing very hard.
It was like, and I love Roll Tide University. The idea that like Alabama was this super woke university, which was the caricature. If you went on X, which again, I get it, it has its pros and its cons. That was the caricature that was being presented. I'm going, come on, this is absurd. And I think DeSantis basically said the same thing as well. So, you can sort of see, I mean, look, where I'd love to, I'm Gen X, where you would love to get, is a point where there aren't an ideological litmus test. And what you're really focused on is how do we support our students? What are our graduation rates? When they graduate, are there measurable differences in their educational attainment? Can they secure employment? All of those sorts of things. And I'd love to get to a point where we evaluate, what is tuition? What is the student debt burden? All of that sort of stuff. I would love to get to the point where we measure the success of an institution based on those like meat and potatoes issues. But I don't know that we're there at this point.
Higher ed is changing, fast. From declining enrollments, falling trust in public institutions, and the rise of artificial intelligence, higher education leaders have never faced greater challenges than they do now. Higher Voltage is a regular podcast hosted by industry veteran Kevin Tyler. In each episode, he talks to higher ed leaders and experts to get their take on what's working, what's not, and what has to change. Higher Voltage isn't just for anyone who works in higher education. It's for anyone who is interested in or cares about higher education. Listen to Higher Voltage anywhere you get your podcasts.
Let's stick with Florida here a little bit. We had a federal court ruling, I believe the second federal court ruling that's come out this week on Florida's Stop Woke Act, which at least at the higher education level had been halted previously. This was the law that attempted to, I guess, limit the kinds of content and discussions you could have in classrooms. And this was an attempt to, I guess, limit the influence of what some politicians saw as progressive ideology on the interpretation of history and issues of race and gender in particular. So, Neal, you want to walk us through this ruling a little bit?
Yeah. So just really quickly, as you said, what's often referred to as Stop Woke Act, which was passed in Florida several years ago, that it put certain limitations on ideas or other things that could be covered in courses. So there was a lower court, a trial court preliminary injunction issued. It had been sitting at the circuit court for a pretty long period of time, but recently we had a decision from a panel, which was not unanimous. It was 2-1. So you had a dissenting opinion that is, worthy to consider as well, because that means that you did have one of the judges who didn't necessarily think that the act was, potentially violative of First Amendment rights. But what we have with this, it's important for Florida because of what it does in relation to essentially some of the anti-DEI legislation that would affect in the classroom. But it also means that we have another circuit court that has decided under this long-standing question now, are there some kind of rights that faculty, could even extend to student learning, may have, at least in the classroom, probably with research, that is protected, even if they're doing this and carrying out their teaching responsibilities in the classroom? And so under a 2006 decision, Garcetti v. Ceballos, which was not a higher ed case, but it dealt with whether if you're a public employee and you're talking, engaging in something about speech and carrying out your official duties, can you have First Amendment protections? And in that case, the Supreme Court said, well, if you're talking in the course of your carrying out your professional duties, you're not going to have these First Amendment rights. But Justice Souter, in a dissenting opinion, said, whoa, we've used this standard to protect academic freedom in higher education. And the majority opinion says, well, David, you raise a good question, but we're not going to decide that today like we often do. And since then, it's been circulating in law review journals and in court cases. But what we have had is not all, but we now have had several federal circuit courts that have rendered decisions or at least indicated in opinions that Garcetti doesn't necessarily apply to faculty speech that relates to teaching and research. And so that's one of the interesting twists about that decision. And if you think about some of the litigation that is trying to challenge laws in Texas, there's this real question of like, is this ever going to come before the Supreme Court? I was recently talking to a group of attorneys, and this was a question that's being litigated in multiple states. And one of the questions was, why is the Supreme Court not ever taken up this issue? But that decision is important for Florida, but it also now means that we have multiple states that say that despite this 2006 decision, Garcetti, when a faculty member is talking in the classroom or something about the research, at least when they're really talking in their area of expertise or doing teaching, they potentially have First Amendment rights that can be available. And that's an important limitation potentially on regulating faculty in the classroom or in some other spaces.
Yeah. Garcetti has sort of hung like this big shadow over higher education for, 20 years now, right?
Yeah, it was 2006 decision.
And I guess it's sort of like, be careful what you wish for when you say, well, people are asking, why doesn't the Supreme Court ruled on this? Is there a sense that maybe nobody wants the current court to rule on this?
One of the things that I think is interesting about these decisions is that you get a weird alignment that I love. And so, for instance, one of the cases that came out of the Sixth Circuit was about a professor, the Meriwether case, a professor who didn't want to use the identified pronouns by a student. And so even people who might support academic freedom, faculty speech under the First Amendment, they didn't love the outcome or what was going on in that case. And so some of these cases, it's interesting because they've involved conservative-leaning professors. And so I think it's this weird alignment of the legal stars in that people, depending on where they're coming from politically, ideologically, they don't quite know what they're wanting. Because I would say that these cases have actually, in these protection of these First Amendment rights, I think if you're wanting to promote intellectual diversity in higher education, I think that's been a pretty good source of protecting that. There's, for instance, a case out that came out of the University of Louisville. It involved a professor who was a professor of medicine, I think, in psychiatry, who gave a lecture in an event involved at a conservative think tank and essentially against a lot of the modes or the conventional wisdom about treating children, individuals with gender dysphoria, and suffered some retaliation. And the court said, no, this person's well within their expertise. It was the group paid for the travel and other things. And so we've got some cases like that they're protections of conservative viewpoints, or at least certainly ones that wouldn't come under woke 1.0. And so I don't know. I think that's a great question why that hasn't moved forward, but maybe one of the case, something out of Florida or Texas or somewhere at some point, it may get taken up. I don't know. Eric or Scott, what do you think of why the court has it? People just don't want it. Nobody wants to put in their chips.
I've certainly read the decision, the 2-1 decision. Do you know, Neal, if there was a request for en banc consideration?
I don't know I can't remember.
Yeah. And look, I mean, this may be a vehicle. I know, I was reading yesterday, there's some cases, I think filed by AAUP here in the Fifth I don't know if it's in the Fifth Circuit yet or if they're still in the district court level that are coming up. I think once the 11th and the Fifth Circuit start weighing in on this, the fact that you got a 2-1 decision in the 11th, who knows what depending on the composition of the panel in the Fifth Circuit, ultimately you might get a decision. I mean, that to me starts laying the groundwork for ultimately the Supreme Court deciding, hey, this is a consequential constitutional issue, obviously. To the extent there's a circuit split on these issues, that raises the ante in terms of why the court hasn't weighed in. I mean, I think one of the things I was surprised about is how long the 11th Circuit kind of sat with this case. I mean, so, and this particular legislative vehicle is still, relatively new. And then, it's taking its time to wind up through the district court and the appellate court. And so I wouldn't be surprised if at some point pretty soon we get the Supreme Court to weigh in. What's interesting to me, and then you start trying to predict how the court would resolve something like this. And, one of you talk about, when I think of the Supreme Court, certainly a decade ago, I mean, it was Justice Kennedy, ultimately, who I think was certainly deferential to institutions of higher education in general, was sensitive to, and by the way, that's kind of, in a simplistic way, the foundational part of his affirmative action jurisprudence is that we're not getting into the weeds here. And some of that was couched in terms of academic freedom as well. There's a way to caricature this court, but I think on an issue like this is going to be remarkably unpredictable. I'm not sure how they would come out on a case like this.
There's I think a number of things that are at least tangentially related here that have popped up this week. First is Harvard won another lawsuit against the government. You may remember about a year ago, the federal district court in Boston gave summary judgment to Harvard University, saying that the federal government's effort to freeze or cancel all its grant funding because of Title VI violations was unconstitutional, and that anti-Semitism had been used as sort of a sham, that it was sort of a cover for a much broader action than the government was authorized to take. So in this case, the government was actually suing Harvard, so it was reversed from that case. And the district court, again, ruled against the administration, basically saying, you didn't follow the Title VI regs to begin with, and also all these incidents took place 2 years ago. And so why are you bothering to sue now? So there's that. And then at the same time that the federal government has opened 2 new investigations over complaints of anti-Jewish bias at San Jose State University and San Francisco State. So, and this is all, again, still remaining the fallout from the campus protests against the war in Gaza. So I guess, the government keeps sort of hammering on this issue, and it seems to have made very little progress, at least in the courts, on these Title VI violations. Scott, you look like you want to jump in here and correct me.
Yeah. So the Harvard decision came out yesterday. It's really short. I think it's a 3-pager. God bless America. We need judges doing more. And then, immediately last night, and again, it kind of fits into some of the themes we've been talking about, which is this conservative critique of the decision, which I go is just hard to square with sort of the conservative critique of a lot of the overreach or the alleged overreach during the Obama administration. I mean, in essence, I don't know how to say this any other way. Title VI and Title IX are designed in a way, first off, to prohibit discrimination based sex, race. I mean, but in terms of the pressure point to kind of secure compliance with that, the idea is what we want before the federal government can claw back federal funds is we want to make sure that, or we want something from a school saying we refuse to comply. But if you get voluntary compliance, which Harvard, and this was a debate in the briefing, which the court gave short shrift to, was, hey, we may have violated the law in the past. Let's just assume that for the sake of argument. We are and agree to comply now. The structure of both of those pieces of legislation is that they're designed to secure compliance, not to create a vehicle for clawing back federal financial funds. There are other ways, and this is where the critique kind of, I think, lost the plot last night, was there are other ways to punish Harvard for violations in the past. And by the way, that's happening. It's called the implied right of action. It's called False Claims Act theories. It might be breach of contract, those sorts of stuff. But in terms of clawing back federal funds, Title VI, first off, clearly, and then Title IX following Title VI were designed to try to secure voluntary compliance before we go through the process of clawing back federal financial funds. And so last night, when this decision came out, there was this kind of concern about, oh my God, this judge has effectively neutered Title VI and Title IX. And it came from folks, again, who had historically been very skeptical of kind of novel interpretations of civil rights laws under previous administrations. And I just thought it was just really odd. But yeah, that it's a really interesting decision. It's, like I said, it's a 3-pager. Anybody can read it. There's an interesting footnote 3 that is probably worth a read. But again, it's like there's just this misunderstanding about what is the role of government in this process when it comes to Title VI and Title IX. And the role is clearly, before we start pulling millions or hundreds of millions of dollars of funds, we need something from the school saying, we're not going to comply. And that's not what the government was able to produce here. And as a result, they lost. But that doesn't mean, I just want to be clear, that doesn't mean that Harvard gets a pass on alleged violations of Title VI or whatever the case may be. No, they're private suits from professors and otherwise that are going to continue to move forward.
Thoughts, Neal?
Yeah, just a couple of things, and I thought that was just a really nice overview and explanation. Is in a way, one of the things that the Trump administration has done is kind of got a hobby of losing in court when it comes to a lot of litigation involving colleges and universities. But I also think that means that some of this has purposes other than trying to necessarily even prevail in litigation, or at least I wonder about that. So, for instance, I think that there are probably constituencies that you're sending messages to by following these actions. And also, there's a really serious ongoing debate about levels of anti-Semitism on college and university campuses. I mean, even if something's not rising to a Title VI violation about having students who are Jewish feeling welcome and any student. So there are those questions. So this is speculation, which is always dangerous, but I sometimes wonder with some of these actions, to what extent is it almost, I don't want to say performative, but maybe I do, that it's a kind of a performative dissent, it's a signaling to different groups about the actions. I think in this case, and I'm not a litigator or someone in court every day, but I just found it pretty paltry about trying to say, I mean, it was a short opinion, but it was pretty convincing to me. It's like, you're not showing that there is ongoing discrimination that the institution is not addressing. And the government didn't really seem to say that, oh yeah, we can do that. It's like, no, we're going to keep pointing you back to things that have happened in the past. And so it leads me to wonder somewhat, again, well, if you're not going to have this really strong kind of attack on this and try to produce something in the basis of documentation of evidence. On the flip side, and this is something that we've talked about in the civil rights front, and this may also come up with in thinking about the recent investigation of Duke, is the Education Department has said that we're not in regulatory action going to use disparate impact. But it seems to me like the government's also saying there's just a general anti-Semitism on Harvard's campus. Like that's almost the undertone. So we're going to be able to take action. And so I think for me, it was just a little bit of a head scratcher, but also a question of, are there some other motives when in undertaking some of these actions to signal to various groups, that the administration's serious?
Well, can I just one quick thing, Eric? Like what Neal said, and I'm going to pivot a little bit about some of this feeling like it's performative. That was my read of the DOJ findings letter on Duke Law School. All right. I mean, Duke Law School produces some really terrible lawyers like this guy. I'm kidding. That was a jab. I hope Kate Feldman listens to this. That was just a jab at Kate Feldman. But there was a big, a really kind of over the top press release on this. And so I was like, all right, I'm going to take a look at it and see what it says. And I was expecting to see like this remarkably well-developed, lengthy record to support the proposition that Duke was violating Title VI in admissions for like a 3-year period. And what you find is there's some statistical evidence to Neal's point, and I'll go back there in a second, but like they fault Duke for like basically employing a tactic that, as far as I understood, came directly from the SFFA opinion and Chief Justice Roberts' discussion about the ways in which you can look for what was it, the essays and things like that,
personal experiences. Students could write
how
about
race
that.
affected their life.
Right.
I mean, it literally almost quotes it verbatim. And then they go and they bold this part of it, if I recall correctly. Duke said they were looking for candidates that could support a diversity of perspectives and experience.
Yes.
And they bolded that. I go, I feel like I'm losing my mind, but it was this big press release. It may have included some exclamation points. And I said, then you kind of dig through it and it's pretty thin. Some of the more interesting evidence they cite to Neal's point is this statistical evidence about LSAT scores and the median LSAT score of a denied Asian applicant or a white applicant and all of that sort of stuff. But at the same time, it's like Duke Law was employing a holistic admissions process. I mean, you could have an LSAT score. It didn't mean you automatically got admitted to Duke's law school. And so trying to unpack why a decision would, and perhaps race played a role. I'm not saying it didn't, but it's a leap to just say, look at the LSAT scores, look at the difference, and therefore there is discrimination. That's not how any of this works. And so, there's this part of me, and so it'll be interesting to see. So now there'll probably be some battle over it. To Neal's point, will the government ultimately be successful? I mean, if this is all they have, I'm deeply skeptical.
This follows in the wake of the numerous medical schools have also now been put under the microscope for their admissions processes. This is becoming, I guess, the latest tactic, right, by the Trump administration to eliminate, I think, anything but the use of raw, admissions scores, test scores, to determine who gets in.
I do want to say something because I try to be really balanced on this, and there were clearly, lest there be any mistake, there were clearly schools. I'm not going to say why I know this. Who in advancing really, post 2020, that, diversity initiatives were doing things that were likely unlawful, right?
Okay.
I mean, and to the extent, I mean, there have been some cases that have come out and they get fully adjudicated. And, I mean, there were clearly in some instances inappropriate preferences given, at least is my reading of the case law to date. I mean, there ain't a lot of cases supporting that. So, but it's a long way of saying it's like, the Department of Justice at Duke had been basically scrutinizing their records for over a year. And I was expecting, I mean, some, just real bombshell allegation. I think they quoted one law professor who says, hey, I think, this is great. This is going to help divert, it was like, this is really thin stuff. So anyway.
And I think that's also true if you read the letter to Yale about discrimination in some of its programs. It's for the headline of it's almost like we've got the smoking gun, and it's underwhelming for supposedly how intensive the investigation had been. Eric, I do think you're onto something with this limiting. In some ways, I'll look at this as the effort to SFFA beyond, and so
Right.
really it this notion of things that are proxy for race. And again, this gets back to some of this blending of liberal, conservative, whatever you want to think about it. I think that first generation student status has often been embraced kind of in a bipartisan way. And it's interesting to me, for instance, in reading about Duke saying, well, first generation is a proxy for race. And so, that was interesting to me to see, because I think first generation status is still something that, again, I think it generally has a bipartisan, joy and excitement when you have a first generation college student or someone who goes to graduate and professional degree, the first one in their family. And so this notion that we're going to identify first gen status or economic status, that these are proxies for race, that to me was interesting, and I'm curious to see how much further that's going to get pushed in terms of what is a proxy for race. It made me think of percentage plans or other different ways, or using geographic recruitment. And again, that also, just to my mind, it made me think, if we're not going to use disparate impact in a lot of other claims, but we're going to start using these other things as proxies, I was like, well, it's going to be interesting to see how you establish the intentional, discrimination that might be going on.
Yeah, it's the Arlington Heights case, and there's been a lot of interesting litigation, I think, in the Second Circuit around some of those selective high schools and admissions and proxy for race. And I was in a conversation at a conference, and I told folks, I was from Austin. They go, yeah, the 10% rule. We think that violates Title VI as well, because the whole purpose of the 10%, the top 10%, which I think is now top 2%, because none of these elite institutions ever expand their undergraduate enrollment to keep their admissions rates really low. That would be a challenge, which, by the way, there were people who, in the Fisher versus University of Texas case, who said, race shouldn't be used explicitly, but you should be able to use it because there's a variety of non-race-based ways to achieve diversity. And now you're not only saying you can't use race, which, okay, but the Arlington Heights critique is, in essence, you can't use non-race-based reasons if the goal is ultimately to promote racial or other sorts of diversity, which there have been experts who testify in that case who have come out and said, man, if I knew that this is where this was going, I would have never testified to that. So it's really interesting. And again, there are lots of really interesting cases that have come out, I think, of the Second Circuit about that particular theory. And it's one, by the way, that I think was Craig Traynor. As soon as Trump came in, I think that initial Dear Colleague letter about DEI and SFFA specifically cited the Arlington Heights line of thinking.
And that letter is now that has been halted, I think, by court action, hasn't it?
I have a hard time keeping track.
Right. Yes. And so many legal actions. Scott, you wanted to discuss a hazing case. This is sort of a specialty of yours.
Yeah, no, I mean, there was a case that came out. I think this was Washington Supreme Court. I think it was a week ago, 2 weeks ago. I know it's gotten a lot of attention. It was a hazing death at a fraternity that I think was at Washington State. And if I'm wrong, I apologize to Washington State University. But long and the short of it was fraternity, been on campus, recognized by the university through its student organization policy. There was some death associated with a lot of alcohol consumption. And the kind of issue, the precise legal issue was, is there a special relationship between the university and, in this case, the fraternity members such that it gives rise and can support a possible negligence claim? And look, the rough version is the court said, look, by virtue of the fact that the university recognizes Greek life organizations, that was part of the argument, that in part creates a special relationship such that it could support, in theory, a negligence claim against the university. And it's really preliminary early on. But an interesting case. And, my kind of pushback was, that might create some really perverse incentives. There's a part of me, by the way, who goes, I don't know why we're in this business anymore, Greek life business. It's like it's the one, not to be glib about it, but because it's reality. It's like this one student organization where, kids routinely get hurt, or, you hear about deaths. I mean, the tragedy, for instance, I think I've talked about this before with Dr. Kimbrough. I mean, I knew the kid at Southern University who was killed in hazing. I think that was band related. No, it was Greek life related. But, long story short, should universities be in this business at all? And at least one of the perverse incentives, perhaps, or unintended consequences from that decision is some schools saying, hey, we're not going to recognize Greek life. And that raises some other associational interest if you're a public university, and perhaps some alumni relations issues as well. But just an interesting case.
And just to clarify, it was Washington State University. It was a 5-4 decision.
Scott, when you mention that case, it makes me, I'm going to leave out some of the details, but I've been curious about another state Supreme Court. It's not fraternity related or Greek related, but several years ago when the California Supreme Court, in the case of the student who was injured in a lab by a student who had mental health issues, and the California Supreme Court, much I think to the chagrin of the university, said, well, potentially this could be liability for the institution. And in that opinion, and I think it may have been Goodwin Liu who wrote the opinion, I can't remember, but essentially talking about this, for the modern college student, the role of the university in taking care of them and recognizing that a lot of these young people are vulnerable. It's their first time from home. So I'm curious if this may be, again, it's in a different context, but I've been very curious to see about any state Supreme Courts that would kind of follow this California example and be like, well, we're going to put more of a cocoon responsibility on institutions than maybe we would have in the past. So I think that's an intriguing decision.
Yeah, Amy Gaida, who is a scholar in this space, and Peter Lake talks about these kind of things as well. Like, what exactly is the relationship between a university and a student? And talk about in loco parentis and all of that sort of stuff. And yeah, depending on the state, the relationship can be thought of, conceived of very differently.
Great job, guys. I think we covered the waterfront today. What are y'all looking forward to in the next week or so that's coming up? Neal, what do you got going on?
Well, at my institution, we will start the semester soon, and the best privilege that I have is I get to work with really great students. I have great colleagues, but working with students, and so I've been in contact with a lot of them over the summer, but I get to to teach and interact with them. And so I really get a lot of energy and enjoy that. So my students may not be looking forward to the classes, but I am.
Yeah, I'm not teaching this semester, which it's just a very busy time. But I feel the same way as Neal. Man, I love being in a classroom. It's a real joy, at least for me. To Neal's point, I'm not sure it's a joy for the people that have to listen to me prattle on. So I'm not doing that, but like work-wise, just so many interesting, complicated projects going on. In terms of like fun stuff, hey, tonight is Friday night. We're gonna go see the bats, which I haven't done in like 4 years. We have bats that live under a bridge in Austin. They come out around 8:30 at night this time of year. So we're going to go watch that. It's like millions and millions of bats. And then I'm going to go see a little silly band here in Austin. And it's called Barfield the Tyrant. So I was going to go see Lionel Richie, who is, but just elected against that.
Excellent. I'm going to head down and this weekend and meet my kids and their spouses in Fredericksburg, Virginia, for a brunch. My son and his wife just moved to Richmond. My daughter-in-law has a teaching gig this year at the University of Richmond in the history department there. So, go Spiders!
Go Spiders! Yes,
go Spiders! And it's her first job after getting her PhD, so she's really excited and. I'm really happy for her to have that. And Richmond's kind of a funky, cool place, so I'm hoping to get down there and visit them as well.
Hey, Neal, good seeing you, buddy.
Yeah,
great seeing both
everybody.
of you. Thanks so much for the invitation.
There you go. Well, look, thanks for tuning in to Campus Docket. You'll find links to everything we discussed today, including related cases, articles, and a full transcript in the show notes and on voltedu.com. Be sure to follow Campus Docket wherever you get your podcast. And while you're there, check out Trusted Voices and Higher Voltage, 2 more podcasts in the Volt lineup that look at higher ed through different lenses. On behalf of the Volt team and my friend Eric Kelderman, thanks again for listening. We'll see you next time.